All right, let's get on the record, please. We're now on the record. This is the state of Idaho versus Bryan Kohberger. Case number CR 29222805. Get that adjusted properly. Okay, great. Couple of things I just want to share. Apologize for the delay. We were supposed to start at 1 o'clock. The hearing that started at 9:30 went a little long, but it was important. You're probably wondering why it was sealed compared to this part of the hearing, and that is because
and it was a
we were dealing with the procedure of the grand jury, the procedures of the grand jury, and there were a lot of details, and the grand jury is secret. So that's why it's sealed, and whether you like it or not, it's baked into our United States Constitution and the Idaho Constitution. So there's a reason for that. I advised camera people not to turn on the cameras until I was on the record, and they turn off when the record is off. I just want to remind you, you just heard Matt talk to you about not having your phones, your laptops to film anything, to record anything. That would be a violation of the rules. And we will take away your laptop or your phone. Some of these rules have been violated in some of our hearings, and I have an obligation to put a stop to that. And I'm sure you're probably interested in this. I haven't put a decision out yet, but what I'm going to do is take control of the cameras in the courtroom. I'm not going to ban cameras in the courtroom, but I need to have more control over what the cameras are doing and what media or people who are not media are doing with the filming. I know I can only control so much, and that's why I continue to urge people to be patient and have some dignity and some restraint. And some of that.
At the end of the day, we all want the same thing. The men and women of
Just so you know, yesterday I issued an order addressing IgG DNA, and there's going to be an order for in-camera review that I'm going to go through. In-camera does not mean anything about a camera. That just means I look at the information before I can share it with the defense. Let's see, what else did I want to kind of share with everybody? I think that's about it. So we're here now on the defense motion to dismiss indictment on grounds of error in grand jury instructions or in the alternative remand for preliminary hearing. So Mr. Logston, I believe, is going to present the argument. Thank you.
Hey, Gar. Well, as Your Honor is aware, I wrote a lengthy brief or two on the subject of where we're supposed to be legally with our grand juries and where we actually are. And as Your Honor let me know this morning, probably not going to change your mind because the Idaho Supreme Court has, I think the court thinks, gone the other way. So I guess I would accept that kind of ruling as long as the court agrees with everything else that happens.
Oh, no,
But
I don't know about that.
assuming that you don't, let's, I guess, just kind of walk through the simple steps here. So at issue in this particular case is Idaho Code 19-1107, and the infamous language in it that says that grand jury ought to find indictments from all evidence before them taken together, unexplained or contradicted, would in their judgment warrant a conviction by a trial. And the first question that a court has to ask is, you start with the plain language, which we argue, what warrants a finding or a conviction by a trial jury is beyond a reasonable doubt. And it meant that back in 1887, when the territory took all of these statutes, almost entirely from the state of California, and it means it today. And then we also pointed out that the great state of California, when had these on their books from back in the 50s, had already a case in 1962 where they said that it's clearly something more than probable cause, but they weren't too specific about exactly what. And the state has pointed out that if you look at really old life dictionaries, it looks like the word warrant means what you might think it does. Old-timey folks, as it does to us, that if it warrants doing something, it means that it would permit doing something. So the plain language seems to support what we're saying. And the biggest problem that I have then is just that obviously everyone in the country disagrees with me, from sea to sun, shining sea, and so I'm now put in a position of trying to explain why that occurred and why, in the year of our Lord 2023, we are suddenly finding out that that's not quite how things are supposed to be. Why did we forget that we passed all these laws? And I don't have a great answer for that, other than I think the only time I ever heard about field codes before I was looking into this was like a really short moment in a class that I took back in law school. So, I mean, it's somewhat famously kind of the first attempt to codify the law of the day back in 1850. And I think what I read in the tea leaves from the New York decisions and the late California decisions is that there was pushback at some of the things that the field code was trying to do. And one of the things the field code very openly said it was trying to do was fix the grand jury system. Because the grand jury system was believed to be essentially broken. For a lot of the same reasons we don't seem to like grand juries very much today. We essentially believe that grand juries were hard to control. Grand juries would essentially always favor whatever it is they were told, and would always be accused. So, as a system to protect people, it didn't seem really to protect them. And they pointed out in the field code, if you go back and read it, that essentially the secrecy aspect of the grand jury is both its most powerful sword and its kind of its worst aspect. You just don't know what you're going to get out of it. And so they create a bunch of statutes that start to rein in what grand juries can and can't do. And they create some scenarios under which grand juries can be used. And they, in New York, they call it the Court of Appeals, it's their Supreme Court, says, even though we have these statutes that say we should only set aside these indictments in these particular moments, clearly there's got to be some sort of a due process protection. If you're going to pass a bunch of statutes that rein in a grand jury, you can show that somebody's not following those to the prejudice of you, and that's going to work for.
Are you tired of managing your wall with staff's picture?
And that doesn't seem to be very controversial. We see similar language in that Gaspar case that we Idaho, 13 or something along those lines. But at the same time, while the state of New York is trying to figure out ways to not have to abide by the language of what would warrant conviction, by essentially saying, if you can tell the grand jury that is their burden, you can also tell them probable cause thing, as long as they hear both of them, it doesn't really matter. And then the state of Idaho says, well, that's not even what that means, without any additional explanation for what they're talking about. And California apparently just kind of forgets about it until sometime after they've already passed a law in the 40s that says you can only dismiss a grand jury indictment if you can show that there wasn't probable cause. And they kind of moves the whole situation because obviously based on the statute. Our situation is such that we have this thing, and the only group that seems to really dislike it is our Supreme Court, who keep having these things where they're like, please, prosecutors, stop telling people it's beyond reasonable doubt. This happens in the early 1900s, and it continues until the 80s, and they finally say, look, we passed a rule, I hope it's clear now, stop saying that your burden is beyond reasonable. Well, as the court knows, the way that those rules get created is a bunch of people that get invited to parties like me in the legal community go and are selected to sit in a room and decide what those rules should say. And there's quite a bit of the time it seems like the Supreme Court will later have an opinion and go, this is weird, why is this one like this? And so to simply say that, well, because the Supreme Court wrote it, that's their opinion on the matter isn't quite accurate. But clearly, the Edmonton court was behind that as a concept. At the same time, nobody was arguing it. Nobody argued about it, the issue, until just now. Well, that's not quite accurate. Obviously, Mr. Nosco raised this in a few district court cases up in Virginia. But nobody's really been.
What is he talking about?
Raising it until this time. So the court says, look, the Supreme Court's already got a rule on this. Supreme Court's already ruled on it. It's just not true. They said, no, you're wrong. There's probable cause. That hasn't been. They ruled a lot of things, but that's not one of the ones. And the fact that they adopted a rule that says something that they believe necessarily set in stone what the law is. So that, at least my favorite issue here, was, can the Idaho Supreme Court override the legislature and lower the burden of proof for them? And that was a tricky one, because we don't really have a case that just comes out and says that the burden, or for that matter, I guess I don't know, we got this all kind of mixed up when we were doing the argument. So the burden of proof, I think we decided, was actually who has to show something. And then it was the standard of proof is the amount that has to be shown. But everybody confuses it all the time, and I'm using it right now as well. But I'll call it the standard of proof just to be less confusing. In any case, the standard of proof is that something that the judiciary has power over. In other words, is that simply a procedural rule, or is it a substantive rule of law burden, which you can also tell them the probable cause thing, as long as they hear both of it, it doesn't really matter. And then the state of Idaho says, well, that's not even what that means, without any additional explanation for what they're talking about. And California apparently just kind of forgets about it until sometime after they've already passed a law in the 40s that says you can only dismiss a grand jury indictment if you can show that there wasn't probable cause. That kind of moots the whole situation because obviously based on statute. Our situation is such that we have this thing on the books, and the only group that seems to really dislike it is our Supreme Court, who keep having these opinions where they're like, please, prosecutors, stop telling people it's beyond reasonable doubt. This happens in the early 1900s, and it continues until the 80s, and they finally say, look, we passed a rule. I hope it's clear now. Stop saying that your burden is beyond reasonable doubt. Well, as the court knows, the way that those rules get created is a bunch of people that get invited to parties, unlike me, in the legal community go and are selected to sit in a room and decide what those rules should say. And there's quite a bit of the time it seems like the Supreme Court will later have an opinion and go, this is weird, why is this one about this? And so to simply say that, well, because the Supreme Court wrote it, that's their opinion on the matter isn't quite accurate. But clearly the Edmonton court was behind that as a concept.
Oh,
Have you
Lord.
ever thought about what happens to your state when you're no longer here to manage it?
At the same time, nobody was arguing with them. Nobody argued. And declared that the standard of proof in our cases was something beyond reasonable doubt. In many other places, what you see them doing instead is having somebody come in and say, well, the legislature set this standard of proof, but we think usually they higher or lower based on, and almost nobody ever says lower is always higher. And we're always arguing that the Constitution clearly must say it in at some higher point to protect people, and then the courts lean in and say, well,
I think the judge gonna deny it, y'all.
Or if you're in the United States Supreme Court, occasionally you say,
All that talking.
this is goofy and we're going to raise it. I couldn't find a case where the Supreme Court or anybody else leaned in and said, we think that the legislature is being a little too protective of its people here. And we're going to move one party versus the other. Typically, in this country, we try to protect the accused, and we believe that those protections are given to us via the Constitution and via these concepts of due process that come to us with common law, which is where it's so messy. Because New York is telling you that you do something else. Well, we could get into all that, but it would be, I think, more philosophical than anything else because the state of Idaho didn't do it that way. The state of Idaho, as a territory, adopts a bunch of codes out of California, a code that they've already looked at, a code that they've already used. This is what you're adopting. You come and get it. The state of Idaho goes and gets it and adopts it. So that's what the state of Idaho has adopted. That the founders that wrote the Constitution did not appear to recognize what was already on the books in this regard. They didn't recognize that because I think it's not still part and parcel of what was thought to be true. The only thing we know is that from 1890 to Edmondson, the Supreme Court of Idaho was repeatedly admonishing prosecutors to stop using a beyond reasonable doubt standard for a grand jury. And that, it seems to me, is pointing to this concept. Maybe we're going to talk about common practice. Common practice looks to have been everybody thought grand jury was beyond reasonable doubt. And it, I don't think this is like in this case is the prosecutor was able to pull it off, and little wonder. I mean, it's still a grand jury. It's still just the prosecutor in a room with 16 citizens, 12 of which have to agree. They get control over basically everything that's being put on. I mean, the guardrails being put in. Hey, let's use admissible evidence. Hey, let's not pull in hearsay witnesses. That kind of thing is not going to somehow make this impossible and make it so that it can't possibly work.
Yeah.
What it's intended to do is just make it so that if you're in a position to get an indictment against somebody, you're going to put on your A game. Obviously, we've been talking a bit about how we don't think that that's what occurred in this particular case. And we certainly don't think that if the court were to adopt this in this particular case, that this would even remotely cut the mustard, because we know from the grand jurors that at least 6 of them wanted to hear more until they were essentially cut off and told probable cause to standard and let people do it.
Probably should cut that, what the grand jurors did or didn't do.
Create task lists for any workflow.
Yeah, I'm trying to get
onboarding,
dressed and go.
works, and reuse them
Gotta
in a
let y'all
clip.
here too.
Turn any document into a template. Automatically populate it with data.
Fair enough. But I'm just pointing out that there's clearly prejudice in the record the court can see from what they want to instruct. It's also, as we argued, clearly going to be fundamental error. If you tell the grand jury that this is the standard and it's actually something else, you can't possibly think that the result that you get is the accurate one, and so you have to do it again. These are fundamental rights that people have, so clearly that would be the way.
Right, but you just agreed that the court and the case law, going back to at least Edmondson have the standard as probable cause. So, to just say, well, they were given the wrong instruction is not exactly the case. I mean, that is the standard that has been used in Idaho for years, maybe 100 years. It was different. It was different there for a period of time, but after Edmondson, I thought that it was pretty much settled. Now, I understand the argument between substantive and procedural, and that's, that can be a legitimate argument, but I'm not sure it's fair to just say, well, they were given the wrong instructions if everybody's using that instruction from the state.
Well, Your Honor, if that were true, then I'm not really sure what I'm doing with my life, because I've spent much of it arguing that things that everyone in the state is doing are wrong.
True.
And occasionally, rarely, but occasionally, somebody says, no, that guy's right, and my client walks out of prison. So
Well, that's fine. You can make an argument that something should change, but are you telling me that other places in the state are giving a different instruction, that it should be beyond a reasonable doubt?
What I'm telling you, Court, is that it appears that up until 1980, that was true. And so the Supreme Court enters its rule, sort of has this ruling that talks about that, but nobody's arguing about it because they don't have access to the internet, and nobody has a copy of the field code or what California was up to.
Well, Justin Weisslein argued about it in a dissent in Edmondson.
And we thank him for it, although.
Okay.
If you
can't
go
say
back-
that there hasn't been an argument about it.
Well. No. You go back and you read what Justice Weisslein did. Justice Weisslein didn't know about the He knew it came out of California.
Some of that.
No,
Oh,
California.
those are earlier. Oh, that's the earlier session.
He has the California code, and he has the stuff from the territories. So that's what he's found. But he doesn't know. If you read the field code, nobody. If you read it, it literally tells you what it's spelled behind it, pretty close.
Let me see. Hold on for a minute. I'm gonna stop right here because I gotta get out. I got to head out, but I just wanted to start on it so I won't miss it. But I see y'all when I get back. I'm out.